Washington, D.C. A lawyer walks into the U.S. Patent Office and hands over a stack of paperwork. Nothing unusual. Patent filings happen there every single day. Except this one is about to become, by some estimates, the single most valuable patent ever granted. It will build an empire worth hundreds of billions of dollars. And the man behind it will be remembered forever as the inventor of the telephone. Here's what almost nobody knows. That same day, in that same building, another man filed almost the exact same invention. He arrived second, by about 2 hours. And for the last 150 years, historians have argued about whether that 2-hour gap was an accident or a cover-up. Act 1. The race. Nobody knew they were running. Meet your two competitors. Alexander Graham Bell, 28 years old, a speech teacher for the deaf in Boston. Not an engineer, not a businessman, just a man obsessed, in every spare hour, with one idea: sending the human voice down a wire. His research was funded by his future father-in-law, a lawyer named Gardner Hubbard, and a wealthy leather merchant named Thomas Sanders, neither of whom fully grasped what they were bankrolling. Elisha Gray, an Ohio farm boy turned electrical engineer, already a respected inventor and co-founder of a company that would grow into Western Electric. If you'd asked anyone in 1875 which of these two men was going to invent the telephone, almost nobody picks the speech teacher. Both were racing to perfect something called the harmonic telegraph, a way to send several telegraph messages down a single wire at once, which was the technology investors actually wanted to fund in 1876. The telephone was closer to a side experiment. Neither man realized the side experiment was about to matter more than the real job. Both men were closing in on the exact same breakthrough, using strikingly similar methods at the exact same time, and neither had any idea how close the other one was. Then, on the morning of February 14, 1876, both of their lawyers walked into the same patent office. Bell's filing was logged as the 5th document received that day. Gray's was the 39th. Officially, Bell won by roughly 2 hours. But here's the twist almost nobody mentions. Patent office clerks stacked incoming paperwork through the day and only logged it hours later. If Gray's filing landed on top of that pile, it may have been recorded last, while physically arriving first. Nobody has ever been able to prove it either way. It's one of history's great unsolved coin flips. Act 2. The man who held the pen. Here's where it gets uncomfortable. Gray hadn't filed a finished invention. He'd filed what's called a caveat, a legal placeholder that basically says, "I'm working on this, hold my place." Bell, meanwhile, filed a complete, finished application. It bought an inventor roughly a year of protection to finish the work without a rival racing ahead and patenting it first, but only if the system kept it sealed. Gray's own attorney, Baldwin, filed it in good faith, trusting that confidentiality. Patent examiners were bound by law to keep competing applications separate and secret from one another. That's the exact rule Wilbur is accused of breaking. Deciding what to do with two overlapping claims came down to one man, patent examiner Zenas Wilbur. Wilbur and Bell's attorney, Marcellus Bailey, had served together in the Civil War. Years later, Wilbur owed Bailey money, and by his own later admission, he was drinking heavily right around the time he was deciding the fate of the telephone patent. In 1886, a decade after the fact, Wilbur signed a sworn affidavit admitting something explosive, that he had shown Bell's camp the confidential contents of Gray's caveat before ever ruling on the case, which was completely against the rules. And there's physical evidence that lines up with the claim. Bell's original application barely described the one detail that would actually make a telephone work: a wire vibrating inside a cup of liquid. But a handwritten note describing exactly that idea appears in the margin of his application. The same idea sitting inside Gray's sealed caveat. Coincidence? Bell swore it was, for the rest of his life. Not everyone believed him. Act 3. The Call That Changed the World. March 7, 1876. Bell is granted U.S. patent number 174,465. 3 days later, using that same liquid transmitter design, Bell makes the first successful voice call in human history to his assistant in the next room. It works. The telephone is born. It's one of the most famous phrases in American history. Here's the detail almost nobody mentions. Within days, Bell and Watson abandoned the liquid transmitter completely. It was messy, unstable, impossible to sell. Every commercial telephone that followed used a purely electromagnetic design instead. The exact piece of technology at the center of the entire scandal wasn't even the one that built the empire. And Gray? When he first heard about it, he wasn't worried. He figured it was a clever scientific trick, a toy, not a real business. His own financial backer had already been steering him towards serious work instead. A machine for sending multiple telegraph messages down a single wire, which looked like the safer bet at the time. By the time Gray understood what he'd actually lost, it was too late. Act 4. The fallout. Gray sued. The case climbed all the way to the U.S. Supreme Court. He lost. He wasn't the only one who tried. Over the next 2 decades, roughly 600 separate lawsuits challenged Bell's patent. His company won every one of them. Even the U.S. government eventually opened a fraud investigation, built partly on Wilbur's own confession, but it stalled for years and was quietly dropped, in part because courts were reluctant to conclude that a group of respected, well-connected attorneys had committed outright fraud. Bell's patent became, by many measures, the most valuable single patent in American history. His company became American Telephone and Telegraph, AT&T. To put that in perspective, within a few decades, Bell's company controlled telephone service for most of the country, and by the time the U.S. government forced its breakup in 1984, it had grown into one of the largest corporations that had ever existed on the planet. All of it traces back to a filing that beat a rival's by about 2 hours. Gray kept inventing. More than 70 patents by the end of his life. A professorship. He even stumbled into building one of the first electronic musical instruments on record. His own company eventually manufactured telephone equipment for the very industry built on the invention he almost owned outright. When he died in 1901, notes found among his belongings suggested that one thing had never stopped eating at him. Act 5, 144 years later. You'd think that after a century and a half, the mystery would finally be settled. It isn't. In 2020, a physics professor went back through the archives and found something new. A letter written by Bell's fiancée, dated weeks before the filing, that appears to back up Bell's version of the story, that he landed on the liquid transmitter idea on his own, roughly a month before Gray ever did. On screen, 1876, 2020, timeline snapping into place. So which is it? A genius who simply finished first? Or the biggest theft in the history of invention buried under a century and a half of paperwork? 2 hours decided it back in 1876. We're still arguing about it today. Outro. If you had to rule on this case, genius or theft, put your verdict in the comments. And if you want the next patent war, Edison versus Tesla and Westinghouse, the war of currents, say so below. That one gets